The meeting of the Planning Commission will come to order. Please rise and follow Commissioner Uva in the Pledge of Allegiance to the flag.
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Will the principal planner please call roll?
Yes. Commissioner Duarte? Sorry.
Present.
Commissioner Guerra?
Here.
Vice Chair Uva?
Present.
Chair Ortiz?
Present. This is a time to set aside for oral communications from the Planning Commission. Does any commissioner wish to make an announcement or report on a conference or meeting or request items for a future agenda? Commissioner Duarte,
None.
Commissioner Uva,
None.
and Commissioner Guerra.
None.
And I have none. Does the interim community development director have any changes to the agenda today?
Just only one change at the end of the agenda. It indicates there's adjournment to Wednesday, June 7th, to your next regular scheduled meeting. We're going to adjourn to a meeting on May 31st of this year. So just wanted to make that quick change.
Thank you. Does the interim community development director have a report on city council actions today?
Just real briefly, at the last council meeting, just to let you know a few things that happened that affect our department. The council approved the action plan for the Community Development Block Grant and Home Investment Partnerships. It's a big program that our department works on. I wanted to let you know that the council did that. Also, the council authorized us to enter into a professional services agreement with GPA Consulting to assist with our historic preservation ordinance, as that's going to come back to the council. That's something that the Planning Commission saw at one point. We're going to be talking about a variety of different things with the council at a future council meeting about historic preservation and the extent of that. And then one other thing I just wanted to mention, that the council did approve a street closure application to Angel City Market for a variety of events that are going to occur over the next year on behalf of the Downtown Downey Improvement Association. So the council did that as well. So just wanted to inform you of a few things that occurred at the last council meeting.
Thank you. Do any commissioners have any questions on the reporting? No? Does the interim community development director have any presentations for today?
No, sir.
Perfect. Moving on to
I'm sorry. We do have a presentation. My mistake.
perfect.
Well, technically, it's my presentation.
Yeah,
That's
exactly.
okay. But I think that's the only spot in which I could place this presentation. I'm going to make sure that staff has that ready for me. Will you be able to do that? Okay, we'll get that taken care of right now. Did everyone get a copy of the presentation?
Yes.
Okay, so also for members of the public, there's a copy of the presentation in the back. If you did not get one, please let us know. There's also a copy of Rosenberg's Rules of Order, just a handout. There should be copies of that in the back as well. Can I start it? Okay, bear with me with the technology. Okay. It's only taking me to those two. Go down there. No, it works. It works. Okay, good. Okay, thank you. Thanks for having me on the agenda. I did promise that I would have a couple of these presentations, and I will try to make them short so we can get to our business items tonight. So again, thank you. You all know who I am, Melissa Crosswaite. We are serving as interim city attorney for the city of Downey. I am with Best and Krieger, and I am of counsel. Before I get to overview of the topics, housekeeping, if you have questions, please go ahead and stop me. I like for these presentations to be a little bit more interactive because we can all read the law, but if you have a person here that can help you work through it and answer your questions, it's always a lot better. So please feel free to stop me at any time. So today what we're going to talk about is the Brown Act. This is a law that you are all already familiar with, so just be kind of a refresher for you. We'll talk a little bit about parliamentary procedure. We'll talk about due process, which is particularly important on the Planning Commission, and we'll talk about findings, which is really more about staff, but I think it's important for you as a commission to know the work that staff does to prepare these resolutions and making sure that they have strong, robust findings and what that entails. So thought that would be important for you to kind of be familiar with as well. So the Brown Act, we all know the Brown Act. It functions every day that we have meetings. As you know, the purpose is for transparency and openness. So the key to the Brown Act really is that, and I have underlined certain keywords, is that all meetings are going to be open and public unless the Brown Act tells you otherwise. So really what that means is everything is open and public unless the law says that it's not. And in our case, we don't have closed session, but city council level, that would be their statutory authority under only very limited and narrow circumstances for a meeting to be closed. Otherwise, everything is open and public.
What is it? I think litigation and personnel items?
Those are two good examples of closed session items.
Yeah.
Correct, yeah. So a couple of key words, right, under the Brown Act is meeting. What is a meeting, right? If you have all these obligations that take place when there's a meeting, what does that constitute? So a meeting is any gathering of a majority of the members at the same time and place. And I'll talk a little bit about same time and place because there are some nuances in the law about serial meetings where you're not technically in the same time and place, but it can be considered a meeting where you will hear, discuss, or deliberate on items that are within your subject matter jurisdiction. So for the council, it's a little bit broader, right? You're a planning commission, so your subject matter jurisdiction is really land use and zoning. But under the law, we try to look at that broadly. So if anything is conceivably under the subject matter jurisdiction, it could be related to land use and zoning. We consider that to be within the subject matter jurisdiction. The important part about meetings is that it's not just about taking votes. So meetings don't just happen when you are taking action. It happens when there's conversations between and among members of a legislative body or a planning commission on issues that have something to do with the work that you do. So it's it's broader. So when do we have a majority? A majority is a quorum. So in our case, we actually have 4, but if we had 5, and either way, it's 3. We have three members of this body constitute a quorum. So what does the Brown Act not apply to? Because again, open and public unless the law says otherwise. And there are some circumstances where the Brown Act does not apply. I've listed some of them here. So attendance in conferences that are open to the public. This is, for example, the League of California Cities. When you attend those conferences, those are not considered meetings in violation of the Brown Act. Town meetings or other similar gatherings that are open, noticed, and are put on by another organization. So if the chamber has certain events, or there's lots of nonprofits in Downey, they have meetings. You can attend those meetings, and that's not a violation of the Brown Act. A quorum can attend. Another exception is anything that is purely social or ceremonial. So something social would be if you all happen to know some of the same people and you attend birthday parties or other celebrations, or in some cases where there's anything ceremonial taking place. Maybe someone is invited to speak at a particular event. Most of the time it's for city council, for example, a mayor. The mayor and majority of the council can attend those events without violating the Brown Act. The only caveat is this is important, that while you can attend these meetings, you can't discuss among yourselves something that's within the subject matter jurisdiction of that body. So you can attend the California League meetings, but then you don't have a conversation outside of whatever the presentation is that has something to do with whatever's within the subject matter jurisdiction. So you can't utilize these exceptions as a way to go around the rule. Makes sense, right? So more about the Brown Act is the agenda requirements, right? Open and public. What does open and public mean? Open and public means that you have to post and you have to notice the meeting, post the agenda, notice the meeting. So you have to give notice of the time, place, and you provide a brief description of every item of business that will be discussed. Brief. Brief can be a couple of sentences. As long as the public knows what you're going to talk about, it's sufficient as a description. And you do the posting 72 hours before a regular meeting or 24 hours before a special meeting. And there are some special rules regarding ADA and alternative formats. And for those who are non-English speakers, there's additional time that's provided to non-English speakers. On all agendas, what's required is you provide an opportunity for the public to speak as well, right? We're here to conduct the city's business, but the public has an opportunity to speak on those items. So what this is the following are what they're allowed to speak on. They're allowed to speak on items of interest to the public. They're allowed to speak either before or during consideration of an item. It's either. Some cities do both, but it's either. Or on items that are not on the agenda but are within the subject matter jurisdiction. Again, subject matter jurisdiction is kind of looked at broadly. City Council has a broader jurisdiction than the Planning Commission, but that's also kind of a limitation. Cities do it different ways. There are cities that have folks comment as each item is presented. That's more common in City Council. For the Planning Commission, we have public hearings. So for public hearings, we do have an opportunity for folks to speak. So in our case, we actually do, in many cases, provide multiple opportunities for the public to comment. So some prohibitions. There's no action allowed on items that are not on the agenda. You have to list it because the idea is that you want to make sure that people know what you're going to talk about. That they know what you're talking about, they can decide whether or not they want to attend. So no discussion or action on items that are not on the agenda. But what can you do? There are some things that are permissible. You can have brief responses to statements or questions from the public. We see that all the time. The point is to be very brief. Every city attorney has a different definition of what brief is, but brief could be just a question or a comment by one or no more than two of the individuals on the commission or the City Council. You can ask questions of staff for clarification. You can make brief announcements on your own activities. You can provide a reference to staff. I think that's a really important one. If there's something that someone comments on and you really think it's important, let us know by saying, could you please follow up on that? Could we put that on the agenda for a future meeting? That's, I think, the best way to handle some of the comments that come from the public. Again, this comes up more on City Council level, but you want to be responsive. The opportunity to be responsive is not necessarily doing public comment because some of the things that folks will bring up are not on the agenda. So just keep that in mind. Again, ask staff to report back at a future meeting. And in some cases, there's a special rule where you can add items by 2/3 vote if there's immediate action. So if something came to the city's attention after the posting of the agenda, you actually can add it if you have to act before the next agenda. It's not often used. We try to make sure that we're on top of things, but things can happen. A grant comes up and we need to get action by the City Council to approve the application of that grant, for example, and because there's a deadline coming up. So it happens, not too often on the Planning Commission. So I mentioned a little earlier that there are some nuances in the Brown Act, right? Same place, time for a meeting. Well, in some circumstances, you can have what's called a serial meeting, which is prohibited. It is not allowed by the Brown Act. It's the use of direct communication, personal intermediaries, or technology that's employed by a majority. You ultimately have a quorum that develops a collective concurrence. So you may not all be in the same place, may not be at the same time, but if there are communications that lead to a collective concurrence and they take different forms, that's also a violation of the Brown Act. So what is a serial meeting? It's a series of communications between less than a quorum. So it could be Commissioner A talking to Commissioner B, and then somehow Commissioner C is connected. And then you have less than a quorum speaking, but it develops into a majority because you end up coming to a concurrence, basically deliberating. We have a definition of concurrence, but it's when you end up deliberating, when you end up discussing something and getting to some sort of an action at some point or some sort of a decision, you can have a violation of the Brown Act. So to give you some more specific examples, right, a hub and spoke is what we use as an example. The hub is the middle, and the spokes are all of the council members or planning commissioners. So you have one person communicating with A, and then communicating with B, and then sharing what they've communicated with A and B with C. And in a 5-member body, you have a violation of the Brown Act. You also have a daisy chain where you have a council member or a commissioner A talking to B, and then B or A talking to C, and then sharing the information from A and B. That's also a violation. It can happen by telephone, right? You're not in the same place, but you are all deliberating or discussing a matter that's within the subject matter jurisdiction. That can be a violation. Email is very notorious. We always say do not hit reply all. You will get communication from staff and it will go to all of the commission. That's permissible. It's unidirectional. We're just giving you the information. We most of the time we'll put you in BCC to make sure that there's no reply all. But if for some reason that happens, please do not hit reply all. Avoid that, because that can be considered a violation of the Brown Act. And it does happen. I have seen it in cities where it's inadvertent and they have had to have the item discussed again because there was a violation of the Brown Act. There was communication outside of a meeting. And then, of course, social media. Social media has made things so much more interesting. It's made it so much better for us in many ways, but it's also it's had us re-examine some of the rules that we have because they were not in place to address social media and how it works. So recently, 2021, AB 992 did address social media, and it did say that, of course, public officials are allowed to communicate on social media. You can use these platforms. You can use Facebook or Instagram or TikTok, whatever, to provide information to the public or to solicit information from the public regarding something that's within the jurisdiction. What's not allowed are two things. You cannot use social media to discuss among yourselves official business, right? So you can't use a group Facebook message, for example, to communicate about something that's coming up on the agenda. You wouldn't want to do that. And it also went a little bit further. It said that when and before I forget, sorry, discuss among yourself is not simply just discussing with words. You can make posts, you can comment, and you can use emojis, right? The thumbs up or thumbs down, that's also considered communication. That's also considered discussing among yourself. And it did go a little bit further to say that when you post or you share as a member of a body, if any other member of the body comments or replies or puts a little emoji, even though it's two of you, it's considered a violation of the Brown Act. So it actually went a little bit further. So be very careful when you are posting information or when you're looking at other posts or shares by other, note who's doing it. And if it's by another member of your body, you should not be replying or sharing or what have you for that social platform. Go ahead. I know.
So
It's,
A council member post, I hope we fix our streets in the next couple of years. Council member B gives it a thumbs up, and council member C gives it a thumbs up. There's nothing before that body, and they're basically saying, we hope we fix the streets. So that could be technically a violation, but there's no real penalty, because the only penalty is to reverse the voting decision. There's no decision made, right?
it would be very difficult to figure out a remedy for that, but I think you could have a problem because it is technically within the subject matter jurisdiction. The fixing of streets is, and you do have a majority. So I think you could have a violation, and it would be, you're right, it would be very difficult to figure out what that remedy would be. I mean, it could just be a violation that doesn't have a remedy, and then there's penalties associated with it. So you may just have to take the penalties and not be able to fix it. Yeah.
See, how about this distinction? Like,
Yeah.
if it's a article, say the Downey Patriot, and they put, "Hey, I hope the city fixes streets," and a council member A likes it, council member B likes it, does that make any difference?
It
who the
depends on
publisher
who
was?
sent it, right? If it's just something you all joined, you're all part of, you all have the Downey Patriot as a Facebook friend or something, then I think you do have to be careful that it's not a collective concurrence of a majority. I think if you have 3 that's posting on that, it could be a problem because it's arguably, I mean, it is the Downey Patriot, so it is certainly within the geographic limits of the city, so arguably one could say it's within the subject matter jurisdiction, depending on what it's talking about. If we use the example of fixing streets, it could be, and if it's something that's being reposted or reshared by a particular council member or a commissioner, then you absolutely do not want to comment on that because you're more limited in that circumstance. Yeah. So, AB 992 did try to answer some questions, but as you could tell, it left a lot of things unanswered. That's pretty typical. So there are some rules relating to disruptions that we should be aware of. And just recently, last year, SB 1100 clarified existing law. I think it clarified existing law and said that you can remove someone for being a disruption to the meeting. You must give them a warning and let them know that they may be removed. That it added language to the Brown Act to actually say that specifically, but I think that's been the practice of most cities beforehand, that you give the warning, you give the person an opportunity to stop their disruptive conduct, and if they don't do so, then the law says you can remove them. Obviously, if there's some sort of a threat of violence or something that's a little bit more imminent, you can take, quicker action. So that was just last year that the legislature passed this legislation. So what's considered a disruption? It's any behavior that actually disrupts, disturbs, impedes, or renders infeasible the orderly conduct of the meeting. We're here to do business. We need to be able to hear each other. We need to be able to hear staff. We need to be able to pay attention. So anything that impedes that is a disruption. So there are penalties if you violate the law. We don't ever want to be in that situation, but it is considered a misdemeanor if you knowingly deprive the public of information. Sorry, did I say knowingly? I think it's willfully. Knows or has reason to know the public is entitled. That's a violation on the commissioners or the members of the council. So there's a mechanism for remedying, for addressing a potential violation. And of course, there's, even if the Brown Act didn't have something, you don't ever want to have your face plastered on a newspaper saying that this particular commissioner or council member violated the Brown Act by doing X, Y, and Z. You don't want to see that. So there's other aspects that are at play here besides just an actual formal penalty from the DA or the FPPC.
So one of the
Yes.
things on there, so nobody's ever been prosecuted for the Brown Act violation?
That's a really great question.
No, I know that for a fact.
Yeah, I don't think anyone's has.
Yeah.
I think they've gotten close, though. I think they, in some cases, right, you will work out a settlement with the DA so that you're not actually convicted. But the DA has an entire unit. It's called the Public Integrity Unit of the DA's office that only addresses potential violations of law by public officials. So they are certainly very busy. But you're right. I don't think I've ever seen anyone prosecuted for a violation of the Brown Act.
And then again, like the penalty is you got to find the remedy for it. And the penalty is usually, if we have a serial discussion and we vote on something and then we were in violation of it somehow, somehow we would be if we did that. So then the penalty is to reverse that and have a hearing and vote on it again where everybody has that. So
Yes, but I think I may have left out that it has to be an intentional. I think the word is intentional.
I agree,
So if you intentionally mean to deprive the public of information, even if you remedy the Brown Act violation from the standpoint of the agency, you could still have some liability for yourself individually if you meant to do that, if you meant to deprive the public of information. So
I think the
that's a
second
good
part
point.
is just as important for us. We don't want the reputation of violating it. whether
100%,
it's a
right.
bad penalty or not. So
Yeah.
that's not the right thing to do.
Absolutely. So we're going to leave the Brown Act and talk a little bit about parliamentary procedure now. Any questions on the Brown Act before we walk away? Nope. Okay. All right. Parliamentary procedure. So technically it's parliamentary law, and it can be pretty formal. What are they? They're just the rules and customs that govern how we conduct ourselves in a meeting. It's really contained in the Roberts Rules of Order, and that's very technical and very formal, and we don't do that. It doesn't make sense for us. So we have an abbreviated form called Rosenberg's Rules of Order, and I did pass a copy of that along to you, and there are copies in the back for members of the public. It's an abbreviated version, and in many cities, we use even more abbreviated version, right? Ultimately, we just want to be able to be organized. So whatever gets us to that point, so long as we're respecting the public's rights and respecting applicants' rights, it's an appropriate procedure. So are you required to follow the parliamentary procedure? You are not. You are not, although I have seen some codes, municipal codes that say we will endeavor to utilize, or sometimes it does say we shall use parliamentary procedures. But even in those cases, we'll do an informal use of parliamentary procedures. Again, it's just about being organized. So these are just kind of some of the principles. As long as you keep these things in mind, you are going to be well within utilizing good organizational skills and parliamentary procedure in kind of a loose sense. So all members have equal rights, right? There's a chair, and in some cases a vice chair will run the meeting, but ultimately everybody is one vote, so everybody has equal rights. The rights of the minority are protected, but the will of the majority prevails, and that's voting, right? It takes a majority to pass a particular resolution or item. Each speaker, it says must, but they should be recognized by the chair prior to speaking. We try to do that. I will sometimes do this, right, to try to get the attention. It's just we all try to be courteous about it. Only one person may speak at a time. And we do have a practice of having all of the remarks addressed to the chair. That's just a practice. It's part of decorum. Only one subject at a time really should be considered. We don't have an issue with that. We try to stay with the agenda, so we try to stick to the same topic. Each topic is entitled to full and free debate. Each person speaks once until everyone has had a chance to speak. We do that. That's what most cities do. They just start at one end and ask each person to provide their comments, and then usually it ends with the chair providing their comments. And of course, we should not be attacking or questioning the motives of other members. You want to keep it courteous. You want to keep it so that everyone can give their opinions and have their opinions respected and not feel like it's some sort of an attack. And I think we do a very good job of that. Every city's different, right? People debate in different ways. Some people get a little more heated than others, but we aim to try to, and the chair is well within their rights to make sure that people stay within the topics and not go to a level of attacking on any personal level any particular member. So some of the motions that we make, the basic motion, this is very basic, but I move to, and I think what I wanted to note, even though I didn't put it on here, is in most cases, what is most appropriate is for you to move to adopt the resolution number. So whenever you can, say, I adopt resolution number so-and-so, because the resolution is what contains everything, right? It has all of the decision in there. It has the findings. So if you say that, if you make that your motion, then we are making sure to incorporate all those findings, which I'll talk about later. The motion to amend, we see it often, and it's when, in many cases, it's when we want to change conditions, for example. You can move to amend the motion to adopt resolution X, Y, and Z by adding or modifying the following conditions. To the extent that you can, you've had debate on something and you kind of know that you want something to change on the resolution, try to make that in your motion. Just, I move to adopt resolution X, Y, and Z. Someone can say, but I'd like to amend it to add the following conditions. We're here to help you with that. In many cases, we're the ones that will either remind you that there may be a condition that you were thinking of, or we help you to articulate that. And in some cases, you kind of just tell us generally, we want a condition that does the following. I'm directing you, staff, to prepare that condition. So you don't have to have the exact language of the condition, but as long as we nod and we understand, we can add that for you. There are motions, there are substitute motions, and that's just basically when someone disagrees and they want to go a different route. You usually vote on that first. And then motions to reconsider. That has to be done at the same meeting, and it has to be made by the prevailing side. Doesn't come up too often, but if you change your mind, but you were on the prevailing side, you approved something, for example, then you can make a motion to consider later on in that meeting. So again, everything is about courtesy and decorum. That's what we care about. One person at a time, recognize each speaker, focus on the agenda item, don't focus on anything extraneous to that. Just stay organized. That's all I wanted to talk about parliamentary procedure. So I want to talk a little bit about your role as a planning commission. So this is directly from the code. I just pulled out one of the sections. This particular section of the code talks about commission authority, talks about staff, talks about city council authority. But this is what you are empowered to do as a planning commission. You review certain applications, you hear and decide appeals that are coming from the planners or from other official actions. And of course, you're deciding on a number of different zoning applications. These are your duties. So there's different kinds of decisions, and I wanted to just kind of cover that real briefly. So there are administrative decisions, right? Over-the-counter type of decisions, staff level decisions. These are typically ministerial. So ministerial is different from discretionary, although there's a lot of debate sometimes on state level as to what is what. But ministerial basically means check the boxes. That's how I think of it as. If it's ministerial, it just means you have to comply with 1 through 10, and that could be pay your fee, submit your application, get the signature of the owner, what have you, depending on what it is. A very simple example is a building permit. A building permit is typically, quote unquote, ministerial. Discretionary is when there's some aspect that is subjective, where there has to be a determination that's made based on personal judgment, really. And that's where you have questions of what fits the character, what fits the neighborhood. That's something discretionary. Staff level determinations are typically ministerial. They're of the other type. You just check the box. You also have legislative decisions. What does that mean? That just means you're making the law, right? So when you're changing the code, you're doing general plan amendments or specific plan amendments. These are legislative actions. There's different rules related to when you approve or deny legislative actions. Then there's, and this is really important for us, because a lot of what we do is quasi-judicial. Quasi judicial means that it's a judge. You're sitting as a judge, as a neutral party that is deciding based on certain facts, whether to grant or not grant a particular entitlement or privilege. So the examples I have are CUPs, variances. These are privileges. And so when it's quasi judicial, there's certain requirements you have to abide by. More so than in the council, you have more decisions that are quasi judicial in nature than they would have. So one requirement is quasi-judicial determinations. They do require a public hearing. That's how you protect the applicant. That's how you sit as a judge and you protect the applicant who's making a request of you for some sort of entitlement. So CUPs, variances, for example, they require a public hearing. So public testimony is taken. You do have to allow the public to speak. They require due process. I'll talk a little bit about what due process entails. And I talk about the process, but I have a different slide that I will talk about that a little bit more in depth. But we have a lot of public hearings on the Planning Commission. Due process is just a constitutional requirement. It means you provide notice, and we do that usually. The agenda is notice, but there's also public noticing that goes on either in the newspaper or sent out to folks that are within a certain radius of the particular application. You have to provide an opportunity to be heard, and that's for the applicant. Whoever's coming before you asking you for this privilege has to have an opportunity to be heard. And you have to have a fair and impartial decision maker. As best as we can, you have to act as a neutral. You're taking in the testimony and you're deciding the matter based on what you hear that day. So how does it usually run? So the public hearing is all of it. Technically, it's really all of it, the entire item. Staff will present their report. That's part of the hearing. You will ask questions of staff. I think at that moment, after the staff has made the report, you're really focusing on questions. What doesn't make sense? What do you need to hear again? Really getting a sense of making sure that you understand what the project is. Questions only, and there's a reason for that. We want to kind of keep our opinions we want to make sure they stay towards the end. After you've heard everything. You don't want to show that you've made up your mind. We'll talk about that. That's called bias. Bias, or just in general having predetermined or prejudice of the decision. So then after you've asked questions of staff, the commission will open the public testimony portion of the public hearing. This is when the public speaks. You always have the applicant speak first. It's important that they speak first. They need to tell you about their project first. We usually will allow more time to the applicant. That makes sense. You don't want to constrain them to 3 minutes. 3 minutes may not be adequate for them to really have a meaningful opportunity to speak. So, and in many cases, you ask questions of the applicant. So that is kind of a moment where you can ask and get information. And so it tends to be longer than the members of the public. Members of the public will speak after. They do get a limited period of time. At the end of the day, if it's a public hearing and it's a quasi-judicial decision, it's the applicant that has the rights to that particular entitlement. So you want to make sure that you're cognizant of that. The public has a right to speak, but you can place limitations on the public's right to speak. You have to get through the application and the public hearing process. It just makes sense. The applicant is always given an opportunity to rebut. In many cases, they don't, but you always want to ask them, just in case anyone has spoken. Do you have anything else that you'd like to add? Then you close your public hearing, and that's when you take your motion. That's when you deliberate. And that's when you vote. If you have additional questions when you're deliberating, I would recommend that you say, I'd like to just open the public hearing one more time to get that testimony, because ultimately the public hearing is what a court will look at. That's the transcript that matters, right? What's being said at that time. So if you do have questions that linger after that you didn't get to ask, it's okay. Make sure everyone is still here. The applicant will typically still be here, and just say, okay, I'm going to open up the public hearing one more time. Can I ask this question? And then ask question of staff. So I think you're aware of this. We do this. We ask for you to disclose ex parte communications or offsite visits. And the reason for that is, again, you always go back to due process. That applicant has to be able to rebut whatever information is being presented. If they don't know that you went out and saw X, Y, and Z, or they don't know that you went out and spoke with a particular person, and you're relying on that, that's not providing due process, because that wasn't in the context of the public hearing. They wouldn't have had an opportunity to rebut it. That's why it's really important that you communicate that you disclose that on the record before the applicant speaks, and that you be as thorough and as detailed as possible. That is just to make sure that there's no issues with due process there. It's just one easy way of doing it. It isn't saying that you can't have the communications or that you can't do a site visit. You certainly can. You just have to disclose it. So actual bias. This is a legal concept. When you have an unacceptable probability of actual bias on the part of you as a decision maker, that means that you are not providing due process because you're not being impartial. So again, this is a legal construct. You have to have concrete facts to show that it's an unacceptable probability of bias. Or actual bias. It is difficult to prove, but I think that when we are functioning, we want to make sure that we're always cognizant of that we're not making it seem that we are not neutral in some way, right? We all have opinions. We can certainly have our opinions. It's not an issue. But if it rises to the level of something where an individual or an applicant could say, well, that person did not give me a fair shake at this, that's where you have a problem. And sometimes it's more so the perception than the actual legal definition or legal determination. So how do we address this risk? You avoid statements prior to the close of the hearing that suggest your mind is made up. So that's why I mentioned earlier, ask questions, ask a lot of questions, but make sure that your statements that are more so an opinion are done at the end, after you've heard everything. Don't pre-commit to decisions. And honestly, if you think you can't be fair, and that happens, I've seen it many times, and it goes both ways. I know this applicant really well. They're a member of my church, or I've known them for 20 years. I really don't think I should participate. I can't really be fair. Or I really don't like this person. I've had lots of problems with them. We're human. That's okay. Let me know, and we can have you not participate. I think that's better than risking some issue, risking the applicant saying that there's been a violation of due process.
Can I ask you a question on that?
Yes, of course.
Again, so we go out, we get the report, and we go out and look at that building that we're supposed to be voting on at the public hearing. So when I go out there, I see it's got a straw roof, okay? And I know for a fact the straw roofs, burn easier. So I have a predisposed disposition to not approve that because of my prior knowledge, and then I went out there and saw it. So, going into the public hearing, I'm probably not going to vote for that. You got to almost convince me on that. So is that something that you think would be a predisposed, on the physical elements of something we saw?
I think when it comes to issues like that, it's kind of an art form, because you may have that in the back of your mind. Ask a question about it, right? And the way that you ask that question may not show any kind of pre-commitment. So that's one aspect of it. But I think your question really is that actually pre-committing? Not necessarily, because you can ask that question and get a really good response. And in that way, you really haven't made up your mind. So it's like I said, it's kind of an art. It's kind of like, it's a little bit more nuanced than just I've made up my mind or not made up my mind. In most cases, you are not going to have a situation where a commissioner or a council member says, well, I know I'm voting against this. Doesn't matter what you say. Like, you're not going to have that. But you certainly have ideas about things. You certainly have opinions about things. You've done this for quite a while. Especially if you've done planning commission, you kind of know what projects look like or should not look like, and you just gather that over time. You can certainly ask questions, and I don't think asking a question, I don't think noting something that could be a problem in a project is the same as saying that you've already made up your mind.
Okay, fair enough. Thank you.
Yeah. So if there's actual bias, you would be disqualified. And this is different from conflicts of interest. This is an entirely different area of law. Conflicts are based on financial interest. This is a lot more, squishy. It's a little more subjective. And if there is a situation where we think that there could be a very high probability of actual bias, then we will ask you to disqualify. That concludes that section. I'm going to talk a little bit. Any questions about that? Public hearings and the process for a public hearing, why it's important.
I do have one question. It was in
Yes.
regards to Shake Shack. Why wasn't she allowed to have a public hearing for her to respond? I remember that she had to go up on non-agenda public comment. So what's the difference between that one and
So not everything is a public hearing. Not everything is required to be a public hearing. Things are required to be a public hearing only when state law says so, or our local law says so. And so in some cases, our local law just says that it's not a public hearing. For example, a special event permit is not a public hearing item. So you just wouldn't attach all the things that you would attach. It wouldn't be noticed. You wouldn't have the applicant speak. It would just be an item that you're looking at. So in some cases, something is just not required to be a public hearing, and that's why it looks a little different. I know it's, we have both here. We have both. We have some processes that do require that it be a public hearing, and then we have some that do not. So, good question. So, findings. I want to talk a little bit about anything else that you want to talk about with regard to public hearings or protocols? Okay. Findings are really much more important for staff. The onus is on us to be able to prepare what's called a finding. There's just criteria that's spelled out in state law or in local law. It's either that tells you that you can only approve if you meet the following criteria. So findings will require us to basically tell you why you should approve or why you should deny something. I call it's showing your work. So findings are required again for a variety of land use decisions, and they can be required by local ordinance. We have several ordinances that require findings. So that's when they're required. You have to it's good practice. In some cases, findings are actually not required, but we include them anyhow. We want to make sure that we say that this is consistent with the general plan, for example. That's a finding, and explain that. It's also, I forgot to mention that, it's also just kind of about the public knowing the why. Since the finding is the answer, it's the why you're doing something, putting them in even when they aren't required is a good practice. So here's an example. You've seen this one before. This is the CUP findings. It's you have to determine that there's four. You have to determine that the CUP will not adversely affect the public, that it meets the requirements or the purposes of the general plan, or that the size and shape are adequate to allow for the development, and that issues with traffic will not impose an undue burden. So staff will go through each one of these, and they will look at the facts of each application and see if they can meet these findings. So they have to be substantive. They cannot just recite the law. A finding that says the proposed development is consistent with the city's general plan is insufficient. You would never see that. They don't need to be formal, but formal findings are a good policy. That's why when I mentioned earlier that your motion should be to approve the resolution, it's because the resolution is the formal way of putting these findings together. And again, they're just about explaining why you're getting to a certain point. I think I missed one. Hold on one second. Okay. Actually, there's a point I want to make, but I think I'm going to make it later about when you disagree with the findings, because there's a way of doing that as well. So they cannot be vague. They cannot be ambiguous. They have to be clear. That's why in many cases, we write it out for you. You don't have to give us the information. It's already there. So again, you are free to use the findings that we have. In some cases, and I've seen it happen, a commission does not agree with staff. They don't agree with them. So in those situations, what we recommend is that you direct staff to prepare findings that are contrary, or to approve or deny, whatever the case may be. You can do it yourself, but if you do try to make the findings yourself, you really have to be very specific about what aspects of the project meet or don't meet a particular criteria. And that's kind of hard to do on the fly here. So the best practice is, because again, you're not obligated to accept them, is to say, staff, we'd like you to come back with a resolution of approval or denial that makes findings for approval or denial, and give us an idea of where you're coming from. What was the issue that made it so that you don't agree that the findings are met? That gives us a little bit of guidance, and then we can prepare it and bring it back to you. So some acceptable sources. When you look back and a court tries to determine whether or not you've made appropriate findings, they'll look at the staff report, they'll look at written and oral testimony, they'll look at your, I'm sorry, you have a question?
I do
Yeah, go
have
ahead.
one question in regards
Yes.
to the findings.
Yes.
So we can, does it have to be a unanimous decision on, do I have to get all my commissioners to agree? Can we get to deny a certain project, or can only be one person vote?
It has to be a majority.
Majority?
So yeah, it's the converse of what you're doing. So if you're approving the resolution, you've got to get a second, and then you've got to get a majority to agree to approve the resolution. If you don't agree with the resolution and you think the project should be denied or approved, it's the same process. You just make a motion, but your motion isn't to approve the resolution. Your motion is to direct staff to come back with a different resolution that makes certain findings, or opposite, that indicates that certain findings cannot be met, and try as best you can to be specific as to which one you mean. It's A, it's B, it's C, it's D. And it's this particular fact that's giving me pause. That would be sufficient for staff to be able to come back with, hopefully sufficient to be able to come back with something. That's a good question. Let's see, Oh, really important, obviously, that findings relate to the purpose of making sure that you have appropriate findings is that you're explaining to the public why you've made a certain decision. And that's typically based on what you've seen that day. So it's really important that findings are based on facts related to that application and no other applications. I know that we get lots of similar applications sometimes, and things will remind you of other applications, but as best you can, well, you need to keep it to whatever is the facts and circumstances of that particular application. Courts have thrown out findings that are based on things that are unrelated. And actually, there's a recent decision that talks about discriminatory statements, things that were discriminatory, things that were against the law. Those were not appropriate findings. So the court threw all that out. So it's very important that you base it on the facts of the particular application and keep it to what's in the code. Okay, I think, I was here. The environmental documents, we'll share the CEQA for you so that you have that as the source of your findings, resolutions. So the transcripts of the hearing where folks are speaking on the project, that's all appropriate sources and appropriate bases for findings. Unacceptable would be transcripts of the meeting debate. The debate that you have is not part of the findings. That's why the public hearing typically closes right before you make your vote into deliberation. The public hearing is where you have all the information that contains acceptable sources. That's where the public speaks. That's where the applicant speaks. That's where you get the information from staff. So the transcripts of the meeting debate isn't sufficient. And boilerplate findings or conclusory findings are obviously not going to be sufficient either, but that's where staff comes in to help you out with that. So again, this is more of the onus is more on staff to do this, but findings are really important. They're part of the decision-making process. We have all that in state law. We have criteria in state law. We have criteria in local law that tells us allows us to make certain decisions based on certain criteria. And it's super important because, of course, we don't want to expose ourselves to any kind of lawsuits or any other type of, again, bad press, right? We did something that we shouldn't have done, and we did not have a basis for doing so. We have to explain ourselves to the public. That's part of our duties here as public officials. And I think that is it. I covered the Brown Act, I covered parliamentary procedure, hearings, and findings. Does anyone have any questions about these issues? Anytime you have a question, always feel free to also, you can contact staff or you can contact me. You have my email address. I'm always happy to answer your questions.
Thank you. It was a great presentation.
Okay, thank you. I'm glad. Okay.
Do any commissioners have any questions with the presentations? Vice Chair Uva?
No, none.
Okay.
Commissioner Duarte?
None for me.
And Commissioner Guerra?
No, but thank you very much. We
You're
appreciate
welcome.
it.
You're welcome. Thank you for your attention.
All right, we're moving along to non-agenda public comment. This is a portion of the agenda that provides an opportunity for the public to address the Planning Commission on non-agenda consent and other business items within the jurisdiction of the Planning Commission and not listed on the agenda. It is requested but not required that you state your name, address, and a subject matter upon which you wish to speak. Please limit your comments for non-agenda items to no more than 4 minutes. Pursuant to the Brown Act, no discussions or actions other than a brief response, referral to the city planning staff, or scheduled for a subsequent agenda shall be taken by the Planning Commission on any issue brought forth under this section. The public, non-agenda public comment is now open. Do we have any speakers?
Well, that was interesting. Thank you very much, Ms. Crosswhite. It was informative. It's good to know how staff and the commissioners are supposed to relate to each other. There are guidelines that should be observed, and it should be as formal as possible. But there's a lot of issues we can go through here that we can't cover in 4 minutes with this. I was intrigued by the 2 + 2 is 5 in the findings. Now, I would have a question. If staff has a finding that 2 + 2 is 4, I would call that an objective truth. But 2 + 2 is 5 is a subjective truth. What if the commissioners disagreed with the finding of staff on a situation like that and tried to tell us that 2 + 2 is 3, 4, or 5, or all 3 at once? Would that be legitimate? Would that be a violation of the Brown Act? I don't know. What if staff came to a finding that there are only 2 genders, male and female, and the commissioners said that there are 72 genders? Would that be an objective truth from the staff to the commissioners? Or would that be tyranny in going against an objective truth? That's not addressed here, okay? Social media. When the public is commenting and council members or commissioners are texting people, assuming that a text can be an official correspondence, are they performing their duty to the public, or are they performing a disservice? Should they be listening to the speaker? That's just a question to think about. In communicating on social media, I'm not a big fan of communicating on Facebook or Instagram. I don't think the council people should have their own accounts and call it official accounts. I don't think they should be able to sit at home and claim to be in attendance of a meeting. They should show up here to the meeting, no matter what. If they're getting any feedback from the public, are those official correspondence? I don't think it is. I personally, I think whatever is going to be discussed and displayed here should be done here. Because we now know that the social media platforms censor people. We know that for a fact. We know the FBI has given instructions to Facebook and Instagram and Google to censor people on official business. And that's called fascism. And the corporations go along with it as well. That's what we have going on here. I don't think we should be allowed to use these platforms for official business. We should just be able to come in here and have our say and have it recorded. And that's why we should have the camera on at all times, every second of the meeting. Thank you very much.
Bruce, here.
So we're going to learn some ideas about vague and ambiguous. Well, first of all, most of these meetings in Downey have been run by the terms that are vague and lack adequate standards and guidelines. It seems that the rules fall in the position of authoritative Nazi regime up there of people that should first learn what the enforcement rules are before hammering down on the public. For example, directing intimidating threats, final warning. No, your responsibility is to give as many warnings as tolerated by you and the public until it becomes a point of a disruption. Otherwise, like I said, you become a fascist, evil, slanderous motherfuckers. And the reason why I have to say that, because again, we're talking about our First Amendment under violations, our Fifth Amendment, our 14th Amendment, and Article Section 2 of the California Constitution, in which at times the interim attorney makes quite a few mistakes by not addressing the issues regarding enforcement of unconstitutional rules of decorum. And I say that because the platform that not just happens here, but what happens in council becomes a unwelcome, lawful excuse to deprive the public exercising their constitutional rights. And if you don't like a person, then just shut up and let them rant or run on what their point of views and opinions are. For example, Brown Act 54950, 54963, you can get a free copy from your assembly person anytime you call them and ask to send you the Brown Act book. That way you can ensure yourself that which violations are a disruption of a meeting. So far, the governor hasn't acknowledged the Brown Act because he's a fool. California idiots are a bunch of fools because you try with your so-called rules, failure to enact laws and rules that give reasonable notice. And the issue of a warning, again, is a failure of a new rule that violates the First Amendment. Isn't that interesting? Inadequate, it's not accountable, and it's vague and ambiguous. So Melissa has a lot to say, but she needs to go back to the reality. The Modesto lawyer who put the Brown Act into action was for the purpose for we the people to be heard and we the people to decide what actions are appropriate in the decision making of our government, not you. You're only the tool that listens to the public. And we define what we like or have an interest in and we will criticize and be outspoken to things that we disagree with, whether you like it or you find it offensive or venomous or caustic. So, once again, here's my documents for the record. FBI at 310-477-6565-110000 Wilshire Boulevard, Suite 1700. I bring that to inform you. Thank you.
Seeing no more speakers, the non-agenda public comment is now closed. Before I move on, I do want to welcome our council member Timothy Horn to our chambers. So thank you so much for coming in today. Moving along to public hearing, seeing that there's no consent calendar or other business available. This is the conditional use permit for a new wireless cellular site, PLN-22-00092, will be continued to date certain on May 31st?
No,
or
actually,
June-
Mr. Chair, if I may, we'd request that that item be continued to June 21st.
June 21st.
Yes.
May I have a motion to continue to date certain for June 21st?
I'll make that motion.
Second.
We have a motion and a second. May we please take a vote?
Motion passes 4-0 to continue PLN-22-00092.
Thank you. Now this is the time to set aside for a public hearing for conditional use permit PLN-23-00033. Does the principal planner have proof of publication?
Yes, Chair.
Will the interim community development director introduce staff making the presentation for today?
Yes, Mr. Chair, members of the commission, Senior Planner Gerardo Marquez will be giving this presentation.
Good evening, Chair, Commissioners, members of the audience. The first case before you tonight is PLN number 23-00033, which is a conditional use permit for the on-site sale of beer and wine, Type 41 license. Subject site is located at 11907 Lakewood Boulevard. As seen here, subject site is highlighted in yellow. Subject site is located on the southwest corner of Lakewood Boulevard and Stewart and Gray Road and holds a zoning designation of C1 Neighborhood Commercial. Subject site is an approximately 43,420 square foot lot. And as you can see, the yellow square there is an existing 1,346 square foot restaurant. Subject site provides approximately a total of 61 parking stalls for all businesses on this commercial strip. Here's an existing street view of the restaurant for the proposed conditional use permit. It's important to note that there will be no additional square footage added to this project as part of this project, no exterior modifications. The picture that you see here is somewhat dated. There is no longer any type of outdoor seating at this location. Here's an existing site plan. As you can see on the left-hand side, the hashed tenant space is the subject site. As mentioned before, there is no additional square footage being added, and the site provides 10 tenant commercial spaces. Here's a floor plan of the existing restaurant. The highlighted yellow area is where the alcohol will be stored, and this will be an ancillary sort of service added to the existing restaurant. This project was presented to the Development Review Committee. No departments expressed any concerns or opposition over the project, and standard conditions were issued. Standard conditions range from no live entertainment will be allowed at this location, and alcohol sales will be sold in conjunction with food sales, and at no point shall alcohol sales exceed the food sales at this location. This concludes staff's presentation.
Thank you for the presentation. Does the Planning Commission have any questions of staff? Vice Chair Uva?
Yes, I just have one question, excuse me, and it's just clarification. I'm just not sure what this means. On page 3 of the staff report, it's talking about that the subject property is adjacent to residentially developed parcels and that no impacts are anticipated related to the noise levels. The question that I have is, conditions include prohibiting live entertainment, sign regulation related to noise in parking lot. What does that mean?
So those are standard conditions that are in our code that relate to the decibel levels that are permitted per our municipal code. And any signage that is required, not part of this, but will be reviewed by staff. And staff has that discretion to review those.
Okay,
Sorry.
got it. Okay, that's it. Thank you.
Commissioner Duarte?
Just one, the restaurant immediately, I believe to the east, Le Coco, does it also have a type 41 license?
I do believe so, yes.
Yeah,
Maybe we approved it.
yeah, I forgot which one. All right, thank you.
Commissioner Guerra?
I know you sent out letters on May the 4th to residents within 500. Did you get any responses from those?
We did not receive any responses.
So the one thing is, I know the photo is dated because I went by there and there's no outdoor seating on there. You're obviously correct. We do have, I think, how do I ask the question versus making a statement out there? There's a lot of things on the signage there on their windows, and they're by percentage of our Downey Municipal Code, you can only have a certain percentage of signage on your windows and stuff. Is that something that we could make a condition of, that they adhere to the window signage percentage that we have in code now? You understand what I'm saying?
Yeah.
Even if you look at the picture, there's a lot of thing on there. It's still very cluttered with that, and I think it's only 30 or 40% of the window can be a signage or so forth.
I do know that there is a condition that references litter or trash.
No,
and-
that's, yeah, I'm
he's-
I
talking
want to make sure.
He's thinking about the signage on the window.
on the
Yes.
windows,
Yeah.
stuff on the windows.
So I do believe that we can modify the conditions of approval to add that.
Okay,
Yeah.
just to comply with our normal code, it's all.
Of course.
Because that one doesn't comply now. Thank you.
You know, I have a follow-up question that Mr. Guerra just triggered for me. I passed by the other day and we talking about the signage, our new signage program. I know we had. I see that, you know, some of the more modern ones, like I think the liquor store, I think there's a nail shop and the restaurant Le Coco. They have they adhere to the new modern signage for the businesses. In terms of this one, is this grandfathered in, or are they going to be complying in the future as part of condition?
Staff has not received any proposal to modify the existing signage. I do have the applicant here, see if that is a possibility in the near future. If you'd like to ask the question of him, I know that he'd probably be able to answer that with more certainty.
Okay. But are they required to change the signage?
They are not required. This is a conditional use permit for
Okay.
the on-site sale, sorry.
Thank you.
That triggered a question. So we approved that a couple of weeks ago on certain buildings on there. So this building does not have a plan to make it all uniform signage, like, I'm talking about the whole building, not just the applicant here.
We process a plan sign program for the site on within a condition, as a standard condition for those projects is that they be renovated within 2 years. So they have up to 2 years for it all to be conforming.
So this whole entire building will have that within 2 years? Okay, well, that's great. Okay,
There it is.
good. Thank you for that. Good.
Mr. Chair, if I can just jump in real quick on the condition. regarding the signage on the windows. There is a condition on the project that's proposed as condition number 2, which indicates unless otherwise expressly specified, all other requirements of the City of Downey Municipal Code shall apply. I don't think that you necessarily have to add a new condition addressing the window signage. We've heard the commission, so we'll make sure that that municipal code section is applied to this property as well. So we'll move forward with that.
And I have no questions. Thank you.
Thank you.
Before I open the public hearing and call the applicant or his or her representative, this will be the time for the planning commissioners to disclose any pre-hearing site visits or pre-hearing discussions that the commissioners may have had about the project. Vice Chair Uva,
I drove by the property early this morning.
Commissioner Duarte,
No disclosures.
Commissioner Guerra,
I've been by the property several times.
and I have driven by the property as well. Will the applicant or his or her representative please come forward to give testimony?
Yes. Hi, good evening. My name is Martin Lopez. I'm the owner of Taqueria Zavala at 11907 Lakewood Boulevard.
Tell us a little bit about your project.
Well, I'd like to be able to sell beer and wine there at my location. As you know, COVID has devastated many businesses, and it impacted my business as well. I lost up to 20% of my business, and I'm still gradually trying to recover it. And there at my restaurant, we've begun selling mariscos, shrimp cocktails, tostadas, and I would like the opportunity to be able to sell a beer so that the people that come in can drink a beer and have their tostadas and their tacos. And I think it would draw a little bit more people that would otherwise go somewhere else. I need to recover my business. I'm hemorrhaging right now, and I'm doing everything that I can to lift up sales. And this is just another element that I can add, another resource that I could add to possibly get people into my restaurant so that I don't lose it. And that's basically the only reason I'm doing it. I've owned the business for 7 years now, and I never felt the need to sell any liquor there. But my business is hemorrhaging right now, and I need all the help I can get. Now, I'm not gonna. I have another business in Pico Rivera that we have an alcohol and beer license. We don't sell a lot of beer there. We don't even advertise it, but it's there. It's available there for the person that wants to go in and enjoy a beer with their meal, and that's what we would like to do here at Taqueria Zavala. We've never had any issues, never had any complaints. We will never sell to anybody that's already under the influence or to a minor, and so it's the only practical thing to do. It's a restaurant, and I'm hoping that you will approve it for that, so to help me out.
Thank you. Do any of the commissioners have questions to the applicant? Vice Chair Uva,
No questions.
Thank you.
Commissioner Duarte,
No questions for me.
Commissioner Guerra,
No question.
and I have no questions. Thank you. The public hearing is now open. Has there been any correspondence in favor or opposition?
There has been none.
Sorry, can you repeat that? There has been?
There has been no correspondence.
Thank you. Is there anyone who would like to speak in favor or opposition of the application? Please come forward.
My name's Everett Allen Greer, local citizen, real estate broker, contractor, MAI appraiser, managed a $155 billion portfolio at B of A for 20 plus years. I'm extremely familiar with commercial real estate, perhaps more than everybody up here. I have two primary questions. When I was a kid in the 60s and early 70s, that was called, I think, the Laugh Stop, or it was a joke store where you would go buy fun things as a kid. So I'm familiar with it. I've been in the city for 62 years. The decibel rating, I think we need a standard around the decibel rating. I attend Messiah Lutheran over at 6th and Paramount, and the church bells used to go off every Sunday when we'd open church. And then when the condos across the street that were the old Downey Community Hospital, when they were built, the city came over and said, you got to turn your church bells down. So think we need some standards about the noise. That's my number one recommendation. Just because I know on the back side of on the west side of it, you have houses right there. It's within 50 yards of some houses. So that's my only concern is the noise. Other than that, I know one or two things about his restaurant in Pico, and he seems like a good guy, so I'm not trying to block alcohol sales. Frankly, I'd be okay if you had restrictions and allowed even hard booze sales. If you have a 50% restriction, as I think I heard, I would say sky's the limit with a 50% restriction. But it's the noise that I'm concerned about. My sister was in a nursing home about 3 buildings down for years. So I'm unfortunately very intimately familiar with the location. And being here for 62 years helps a lot. That's it. Alan Greer. Thank you.
Anybody else who wants to speak in favor or opposition? Please come forward.
Good evening. I am a resident that's right on the west side of the building. Closer? How's that? Good evening. I'm a resident of the west side of the property. I was here about a year or two ago when you guys permitted Licoco to have a beer license. And I was told that they were gonna post signs for fire, no parking. From the north to the south, on back of the building, it's just crammed with people parking, illegally parking. My concern was we had a fire about 2-3 years in the back of there. The fire department couldn't get in. I was told by someone on this corner that they were gonna post signs and send the traffic. That has never happened. I wish that if we're gonna be issuing license for more traffic to come in, just post the signs and let's have an opening for our fire department to have access in case of a fire. And I've been a resident for 32 years. So I hope that you guys can comply with all of us and that we can all just work together. Thank you.
Quick thought. Mr. Duarte mentioned the modern signage. Is that objective or subjective? That's just your opinion, right? That's subjective. Okay. But we have to have a law or an ordinance that says otherwise. Okay. Sounds like Licoco's alcoholic consumers are causing problems in the parking lot over there. I don't know, maybe. That's subjective too. I'm being sarcastic about that. Look, every restaurant probably sells beer and wine. I think what's interesting is you've got a business owner coming in here looking to you to solve the problem that you have created by locking down the city when you did, and the council, by going along with all the COVID lockdowns. You had absolutely no business doing that. You had no right to do that. And then you try to use the excuse that you went along with the LA County in making people stay at home, not leaving their homes, not being able to go to SeaWorld or to the movies or to a restaurant. At least the outdoor stuff is off the street. That's a good thing. And everybody's going to be moved inside. But to say that alcohol consumption is not going to affect the neighborhood, I think is a little disingenuous. But I'm not going to oppose this gentleman being able to sell alcohol, having a few tacos. I mean, everybody I know would consume alcohol and have a few tacos. I'm not a drinker, but It's just a thought that that these things do happen, but you can't be so naive that, I know things go on. Look at Tacos Don Goyos over there. You've done nothing about that over there to help those people out. And this guy's in here asking you to help him, but you've created the problem. This is insanity is what it is. Government can't do anything. Yeah, I'm going to keep saying this. You guys could run the Sahara Desert and there'd be a shortage of sand within 6 months. But what we saw here tonight, though, there's a separation between the commissioners and council and staff. Staff can give you objective truths, but you don't have to go along with it. That's the key thing. That's tyranny. Because you also, what was overlooked is you have a fiduciary responsibility to the residents, even though you mouth certain things, like in your opening statements and stuff. And I wonder if that's legitimate correspondence or not. Approve his permit. Thank you.
Whoo-wee. Look at here. Beer and wine license at an eating place. That's the best subject for the night. Matter of fact, I'm here in support of the applicant, Mr. Lopez. And matter of fact, I'm requesting and petitioning on his behalf that the mayor get a letter from this commission to give this man a small loan, a very low interest, to establish his business the way he had it operating before COVID. Because that's the clarity about Downey, is that we want to show the world that we are number one at supporting our small business people. And I'm in support of that because I'm one hard-working nigger, and I want to make sure that everyone is entitled to their entitlements of fairness when operating for a beer and liquor license. It's not beer and liquor that causes a problem. It's a person who's out of control and consumes too much and gets behind the wheel of a car like an asshole and goes out there and kills people. The car is not the problem of the alcohol. It's usually the government who started this prohibition shit, just like they did, for example, what Measure 64. Let's just sell cannabis and all smoke and get high as recreational activities. But going back to this restaurant, the gentleman's last call is at 8:30. That's great. It should be at 8:59 p.m. because, as you heard, he's hemorrhaging for support, help, and additional monies from our local government to support his small business. And that would be an impressive move by our dumb fat mayor to look into this matter along with you clowns, because this does not result in any impact to the community. If you don't want to drink alcohol at a restaurant, then take your fucking shit to some church and eat there. Now, if you like to go to church and eat and drink, then go to that church. But I'm in support of Mr. Lopez, the plaintiff, in his action to continue with his interest in Downey and provide tacos. As you heard, he already has a license to sell alcohol in another venue in another city. So he has good standing at this point. Now, if you have anything to criticize him about maybe his standing not being good, prove it tonight. Otherwise, stamp and approve his conditions to go forward with his beer and alcohol license under the ABC. Much appreciated. Thank you.
Seeing that there's no more speakers, does the applicant care for a rebuttal? No. We're good? The public hearing is now closed. Does the planning staff have a recommendation?
Staff recommends that the commission approve the attached resolution for project number PLN 23-00033.
Thank you. It is now time for the Planning Commission to deliberate. Does the commission have any questions at this time, or would the commission like to discuss the item? Vice Chair Uva,
No questions.
Commissioner Duarte,
No, I'm in favor of the project. I would just like to ask staff, just like the young lady that testified, in terms, I remember when we.
Sorry, could Mr. Duarte speak up? We can't hear you up here.
This guy. I'm sorry about that. I just said I'd like to hopefully just tell staff, I remember when we did grant the license for La Coco, there was discussion on that, the back end, I guess, of the alcohol, the liquor store, and that there's like a little alleyway. I know there was some discussion about parking there, and that was a point that was made by citizens in the audience. And I think that's a point that we made when we approved it, just to make sure that people don't park there. So I just, hopefully we get somebody from our, I don't know if it's Public Works or what department to go just check that out.
Commissioner Guerra?
Probably code enforcement or something too. But no, I approve of this project. I'm surprised, sir, you haven't come before to ask for this. The times are very reasonable. What he's asking for is reasonable. The location already has beer and wine there. It seems like it could be building into a problem. I'm sure it's not for this applicant, but that's something I hope our staff and our code enforcement look at, what Commissioner Duarte was talking about. But no, I think he's already has experience with it too, another location. So this is like the perfect fit for that. So I'm all in favor of it.
And I have no other questions besides a comment. I wish you luck. I'm also in favor of it. As a small business owner, I understand how hard it was during COVID and the struggles we had to rebuild back. And so I feel for you. Hopefully this works out for you. What is the pleasure of the Planning Commission? May I have a motion?
Mr. Chair, I'll make
Yes.
a motion that we accept the application.
May I have a second?
I'll second.
We have a first and a second. May we take a vote? Okay. Congratulations. The action of the Planning Commission will become final unless appealed by a member of the public within a 50-day appeal period. Moving forward to, does the interim community development director have any business to discuss?
No, sir.
Does the interim community development director have any additional comments for today?
No, sir. Thank you.
Do any of the commissioners have any other items to discuss for today? Vice Chair Uva,
No, I don't have anything else.
Commissioner Duarte,
None for me.
Commissioner Guerra.
No, sir.
Meeting adjourned to May 31st.